hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain unalienable
All
rights.
right, welcome back to the next episode of the BC Law Just Law podcast. I'm Tom Blakely. We're here today with Professor Fred Yen, BC Law. Professor Yen, how are you?
I'm doing very well, thank you.
Great. We're here today to talk about, this case that's come out of the Supreme Court regarding the NCAA. I know that sports are exciting, particularly college sports, and I know it's been a sort of a flashpoint issue over the last few years, really sometime, particularly over the last few years. The extent to which the NCAA, of course, prohibits, or I guess prohibited, student athletes from being able to, be compensated in some way, shape, or form, from their involvement in college sports. This has obviously been something that's been debated quite a bit, and the Supreme Court's finally, had its say on this issue. That's obviously going to chart a new course for the way that college athletes are now able to receive some type of compensation from their involvement in sports. Before we talk about the case, tell us about yourself.
Well, I've taught at Boston College Law School for over 30 years. My principal area of expertise is intellectual property, copyright law is specialty. I teach torts, and I teach a sports law class as well.
Awesome, awesome. So I guess getting into this case, so NCAA versus Alston is the case here. So I guess just tell us a little bit about the background of the case. I mean, I know obviously the issue of whether or not athletes should be paid is not a new debate by any stretch of the imagination. But finally, after a good number of years here, we finally are at this point where a case came before the court, as it's presently constituted, looked at this and said that things need to change. And so now the NCAA, Emmert, obviously the leadership there, and a lot of people are figuring out kind of what things are going to look like going forward. But how did we get to this point? I know that things have been the way that they were. The status quo kind of was as it was for some time in terms of college athletes not being able to be compensated at all, and even facing punishment and sanctions if they were found to be profiting under the table or behind the scenes. And now it seems like we've gotten to the juncture where enough was enough. But how did we get to this point where change was necessary?
Well, the background for the case, as you mentioned, is the NCAA's insistence that college athletes be amateurs. However, that is to be defined, because of course they don't do it for nothing. Many of them do get something. And so what does that mean to be an amateur is something that the NCAA has always been changing.
Mm-hmm.
It changes every few years, it seems. Now, the direct background for the case is that at some point, NCAA athletes wanted a declaration that the NCAA's restrictions on their being paid, if you will, needed to change. They wanted a declaration that that was a violation of the antitrust law. And this probably really begins back in a famous case that many people have heard about, the case brought by Ed O'Bannon, in which he contended that NCAA restrictions prohibiting athletes from profiting from their name, image, and likeness were a violation of the antitrust law. Now, he won that case, both in the district court and at the Ninth Circuit. But, and this is a theme that will come back, the approach taken by the district court and affirmed by the Ninth Circuit was what I might call extremely incrementalist. There was a declaration that there was a violation of the antitrust law, but the remedy was very small compared to what it might have been. So instead of saying, well, open season, athletes can profit from their name, image, and likeness in any way they want, what really ended up happening after the Ninth Circuit was done with it was that the NCAA was forced to raise the limit of what it allowed institutions to give to their athletes as their educational scholarship benefit. After the O'Bannon case was decided, this other case came along. In fact, and this is the case that ultimately gets to the Supreme Court, in which athletes are now not only complaining about the name, image, and likeness requirement, but about all of the restrictions that the NCAA places on athlete compensation. And that's the case that the district court decides somewhat in favor of the plaintiffs and ultimately arrives at the Supreme Court.
Okay. Now, going back just a little bit, so obviously the NCAA has had a longstanding position that college athletes are amateurs, as you say, and as you say, however that sort of is to be defined. But for amateurs, the NCAA certainly made quite a bit of money off of the exhibition of what they describe as amateur athletes. But sort of that policy regime that was in place for a long period of time that college athletes cannot be paid; they're amateurs. You can't profit off your jersey or your name or in any way, shape, or form. What was, I guess, the NCAA's rationale for insisting, insisting that that be the way that things are?
Well, I can give you the proffered rationale.
Right, and I understand there's probably a distinction between what they say and what might be the reality.
So I think the NCAA's position would be that college sports should be primarily a recreational activity undertaken as an adjunct to an education.
Hmm.
Education is really what the students are at college for.
Hmm.
And if they play sports on the side, well, sound mind and sound body kind of thing.
Hmm.
And therefore, NCAA sports are really about people, partaken by people who are interested in something else more than their sport.
Hmm.
That's the first part, right? That's what colleges are trying to do. Now, when we get to the commercialization of NCAA sports, the huge TV rights for March Madness,
Hmm.
for example, they would say further that the consuming public wants to watch amateur sports, not professional sports. So not only is this primarily about students who pursue sport as an avocation and not as a profession, but that there is a public demand for that kind of sport and that courts ought to permit the NCAA to maintain that system.
A few years ago, I think I saw say something along the lines of, well, college, you have the opportunity to, compete to become a professional, but I think it's like 1% of NCAA athletes actually at some point have the opportunity to go to a professional league. I know you've seen, stories from college athletes talking about having, financial difficulty, being, hungry, being, having to go back and forth between practices and being in. I think I saw this one documentary at some point talks about some schools being registered for, I guess you wouldn't say fake classes, but classes that are designed to make sure that the student athletes are able to get whatever minimum GPA they need in order to compete. Because it seems like from the school's perspective, at the end of the day, these student athletes are assets. The schools and the NCAA make a lot of money off of the exhibition of sports, and it seems like the emphasis that's placed upon their education isn't always particularly strong, at least to the extent that the NCAA's had the position that they're students first. So do you think that and I know that a lot of people look upon the NCAA and the amount of just really the monopoly profits in a literal sense that they've made, as being sort of dishonest or sort of duplicitous with regard to how the industry actually works? Or do you think that that this position that these are student athletes, they're students first, we care about their education, is really as genuine as they might have led you to believe?
I don't want to accuse anybody of being dishonest. I think
Okay.
that that's not a wise thing to do. I think it's fair to say that the lived experience of
Hmm.
many NCAA athletes, whether in revenue sports or non revenue sports, is that the amount of time that the athlete spends required, you know, coaching sessions, practice, weight training, fitness, game travel, film session, is 35 to 40 hours a week. That's a pretty conservative estimate. And I think that for some athletes, it's more than that. And so simply looking at the number of hours one has in a week, if you've spent 35 to 40 hours a week pursuing a sport, which presumably makes you tired, so you need to rest at some point, the amount of time one has left to study is smaller than it would be for the general student body. Now, in fairness, some NCAA athletes are are extremely successful in the classroom, including in Division One basketball and football. There are people who make very, very impressive achievement in the classroom. But we also hear stories, as you said, about students who have great difficulty keeping up in the classroom under those conditions. And in some cases, universities make it easier for them to stay eligible than it would be were they not athletes.
Okay. Now, another thing is there's an important distinction to make between, student athletes being paid in the same way that, professional athletes are paid, versus student athletes having the opportunity to, see sponsorships or, profit from their likeness or sort of these ancillary sources of revenue. Can you just help us understand, the distinction, I guess, because the court does, sort of get into this a little bit, in the case that, it is acceptable for student athletes to be able to, I guess if I don't know, McDonald's wants to give me a sponsorship or something like, versus being paid a salary in the same way that a professional athlete is paid. Can you just help us understand that distinction?
In the court's mind, I believe the court is distinguishing being paid either for simply playing, like a
Hmm.
salary. I play for the Boston Celtics and they pay me a salary of $2 million a year to play basketball, or being given prize money for winning a competition. I just won the Masters and I got $1 million. Um, and money that one might make because one is well known for being an athlete.
Hmm.
In the court's mind, there is a distinction between the former, those are professionals, and everyone else. I don't think the court necessarily calls them amateurs, but they are distinguishable from those who are professionals, and that may have implications for antitrust law.
Okay. Now, sort of another facet of this that we sort of want to talk about is this idea that, like you say, it's an antitrust issue, but at the same time, you look at some of the precedent that the court cites in the case. Whenever we talk about antitrust issues, there's sort of a handful of seminal cases that get brought up, but it is an area where there's not a lot of new law being made. I mean, you see cases regarding railroads, regarding American Express, of course, the financial, the credit card company, but there's not, it seems, often a lot of new law or new case law on antitrust issues. And so you have, whether it's this or whether it's, I mean, if you go aside from this issue, looking at, another big conversation in the legal and sort of political world right now is big tech. Are these companies too big? And you have antitrust law that's quite antiquated. So does the court or do courts have difficulty trying to get pretty old case law and apply it to some pretty novel issues?
Uh, when it comes to this particular issue,
Hmm.
I don't think that antitrust law is struggling.
Hmm.
I think when we talk about how one might deal with Facebook or Google or something like that, that might be a little harder. And I hasten to say that I'm not an antitrust expert, so I don't want to opine too far beyond the realm of sports. But the law that's being applied in the Alston case is the rule of reason,
Hmm.
which is the standard analysis for the overwhelming majority of antitrust cases. And it simply involves the plaintiffs have to identify a practice that they sufficiently demonstrate is anti competitive.
Hmm.
Then the attention turns to the defendant, which has to say, well, it may be anti competitive in this way, but it's pro competitive in some other way that would perhaps justify uh, its its existence, the restraint's existence, and then the plaintiff would have to show that there was some less restrictive way for the defendant to achieve the same pro-competitive result. In other words, with fewer anti-competitive effects. And I don't think that that analysis is tortured at all to meet the facts of these particular cases.
Okay. Now, could you just talk a little bit more about, no, of course, this was a unanimous decision by the court, and just talk a little bit more about the rule of reason. We talk about antitrust and being anti-competitive. Now, of course, if you want to do college sports, the NCAA is really the only game in town. So is the court saying that, if student athletes want to profit from their image like this, they have nowhere else to turn since, if you're at a college in America, you're going to be faced with the NCAA and its regulations, or is it, anti-competitive in the sense that, student athletes, when they go to school, they're forced to kind of contend with whatever the rules of that. Like, where is it that the antitrust violation goes? Is the NCAA too big, or is it that they're only the only game in town, or the rules too restrictive? How does the court arrive at that conclusion?
Okay, so in responding to your question, let me make sure that we understand exactly what is being considered in the Alston
Hmm.
case and to separate that from name, image, and likeness questions, which are largely being pushed now by the advent of state laws requiring leagues, schools, and associations like the NCAA not to penalize students for pursuing profit in name, image, and likeness. So that's something that's happening outside the auspices of antitrust law right now. In the Alston case itself, what is being looked at are the NCAA's restrictions on compensation to athletes. So universities can't pay athletes for uh, participating in sports, and the limitations on what a scholarship or other academic aid can contain. The way the Alston case ultimately comes to the Supreme Court is it's only about the academic scholarship aspect. The players chose not to push the larger question of payments in general. And so the opinion is entirely devoted towards the NCAA's restrictions on academic related aid.
And why would you say that why do you think that the athletes chose, or the council on behalf of the athletes chose not to advance that argument in particular, the broader argument of payments to them generally?
Well, that's an interesting question. And so I'm purely speculating here.
Right.
First, it's not apparent to me that when athletes are worried about what the NCAA offers them, that a salary is what they want. Remember, for the vast majority of NCAA athletes, salary wouldn't be worth very much to them because, what's a third string place kicker on a football team going to get? It's not worth very much. However, the academic grant and aid is real money, right? At a public school, it's worth tens of thousands of dollars, and it might be approaching close to $100,000 value in a year at some private institutions now. And so they might care more about what they're offered there.
Mm-hmm.
That's just speculation on my part. It's also possible that they didn't think they had the factual record to win on that issue on general payment. And the last thing I guess I would say is this, that if you look at the progression of antitrust litigation against the NCAA, I think I would use the pace of progress as incremental.
Mm-hmm.
O'Bannon cracks the door open by getting a declaration that some NCAA rules are a violation of the antitrust law, but the remedy given by the court means almost nothing.
Mm-hmm.
Then in this case, you get another declaration that NCAA rules are a violation of the antitrust laws. And now maybe the remedy means a little something. But I think if we discuss it, it's hardly revolutionary.
Mm-hmm.
I think that in some ways, it's smart of plaintiffs to sort of ease courts into the water.
Mm-hmm.
Because if you said, look, it's open season now and Alabama can pay its players whatever it wants,
Mm-hmm.
and if Vanderbilt doesn't want to do it, well, that's just too bad for Vanderbilt, that courts would be reluctant to go that far.
Okay. Now, sticking with that issue for a second, do you think that this is a matter of, the right court looking at this issue? Do you think it's a matter more so of the right case coming before the court? Or do you think that perhaps, political developments, social developments, different attitudes have sort of been galvanized towards the side of, student athletes being able to be paid? Because I know the court's decision begins with this sort of brief retelling or reference to the first exhibition of college sports in America being this boat race in New Hampshire between Harvard and Yale. And so sort of between that point in time and quite recently, the rule on the books has been what it is, that the NCAA can prohibit athletes from profiting. And now at once things have changed. So how do you think that now 2021 at this point in time we finally got to the place where this was possible? Was it the right case, the right core? I mean, it was a unanimous decision, or have folks just attitudes towards this issue changed, or is it some other thing?
Wow, that's kind of a hard question to answer because you're sort of asking for a large cultural observation as well as a legal observation. If one were to wind the clock back 40 years,
Mm-hmm.
NCAA sports might passably have fit under the description largely a recreational activity.
Mm-hmm.
Yeah, a little money gets made off it by the colleges and the public is interested in watching it, but yeah, it's largely a recreational activity. Today, that characterization is really hard to stomach.
Right.
particularly in the revenue sports. The size of the March Madness contract, the size of the BCS contract, the amount of compensation paid to head coaches and assistant
I
coaches.
think didn't Justice Thomas ask during the case, was that one of his questions? Why are coaches paid so much? I think there was like something along those lines. Like, I mean,
I don't know if he asked that
the,
question or
the
not, but
numbers are certainly quite large for how these folks are paid.
yeah, I mean they make really big money. And
Hmm.
so at this point, it's really hard to say this is primarily a recreational activity any
Hmm.
longer. And I think that quite fairly, I imagine that the compensation of athletic directors at the top schools and the conference commissioners in the top conferences is also very large.
Hmm.
And so it no longer feels like a recreational activity. And so it just feels right that antitrust law has something to say about commerce where the employees are effectively paid nothing but a scholarship.
Right, exactly. So looking to the issue of, sort of like trademark and intellectual property in the sort of the vehicles through which these student athletes can profit from or make some type of profit. So obviously, you've got your name, you've got your image, you've got different things that you're now able to market. So I guess what's involved in, I guess from a legal perspective, if I'm a student athlete and I want to try to make some money during my pretty brief window to do so while I'm, a public facing student athlete that's, on ESPN perhaps. A lot of these kids are like, 18, so I assume these are not folks who are particularly um going to know what to do, will need representation. So I know within professional sports you obviously have agents, you've got, the major players like Drew Rosenhaus and these other names that you hear, but within college sports, I guess, is there sort of a new I don't know if you'd say industry, but is there now an opportunity for there to be agents for, let's say, kids coming out of high school going to D1 schools that want to try to take advantage, exploit the opportunities that are there, because before those opportunities didn't exist. And now I'm just wondering, is there a need for more, I guess, like sports agents for younger people, or is it how do you think exactly that's going to work? If I'm coming out of high school, I've got a just had signing day, the big, I'm going to be a quarterback at Auburn or one of these schools, and I want to make some money. How's that going to work?
Well, the short answer to your question is yes.
Hmm.
There's a new industry that's been created.
Hmm.
There was a report in today's Boston Globe in which reporting that Nick Saban casually mentioned that the new starting quarterback for Alabama next year has begun to exploit his name, image, and likeness. And the figure that Saban was bandying about was near $1 million.
Mm,
So, yeah, there's an industry here.
okay.
Uh, and that means there will be agents and other people involved.
Okay.
Now, I think that one has to, as one would in any situation like this involving intellectual property, if one were a young athlete in this situation, to think carefully about exactly what is the objective, right? So, in other words, somebody who's a famous athlete, again, star running back for University of Southern California,
Hmm.
could probably make a few phone calls or have someone make a few phone calls, local car dealership,
Hmm. Right.
you know,
Whatever it
Dick's
is.
Sporting Goods, I don't know,
Hmm.
whatever it is, right? And land some endorsement deals of the sort, I will appear in commercials for you
Hmm.
and you will pay me.
Okay.
But I think that there is also now the opportunities for athletes to start branding themselves for a lot longer.
Hmm.
Not every athlete who is going to be successful in doing this is necessarily going to be a household name.
Hmm.
So, for example, uh, there may well be a relatively obscure player who's very good at using social media to, you know, give an
Promote
insight to
themselves,
an
right?
athlete's life, or promote him or herself,
Hmm.
right? In some of the minor sports, there are very significant followings for figure skaters,
Hmm.
gymnasts, uh, and those people can really think about branding and becoming influencers and stuff like that. And so that suggests to me a lot more than just making a few phone calls, but
Hmm.
really a strategy for marketing oneself as a personality.
Hmm.
Uh,
Okay.
it's a little bit like, I guess, a version of the Kardashians or something.
Yeah. Now turning to sort of that point, sort of the economics of the issue. You think about how the NCAA and all the different sports that kids can go to, college to compete in. I mean, there's a wide array, but only I think so many of those sports are particularly popular or even profitable. Obviously, football, basketball. within the United States, for football conferences like the SEC, the March Madness tournament just generate massive amounts of revenue, whereas maybe some other sports don't generate near things. I mean, I don't want to go through and like pick on particular sports, but I think the point is sort of understood that you've got some sports which are more niche in nature, and so now you've got obviously if I'm the quarterback at Alabama versus being someone who's I don't know doing I don't know like some other more niche, more I don't know, might say hobby, a sport that's sports, basically sports you're not going to see on ESPN. Obviously, the opportunity that's there in terms of the ability to make money is fundamentally different. So, do you see, this being an issue? Not, I guess, turning away from the athlete's point, but within the schools. Like, if I'm a school that's a powerhouse at football versus another school, obviously the financial opportunities that are there are going to be different. So do you see that this becoming problematic in terms of, like, I don't think inequality is the right word, but obviously you've got some athletes in some schools that are in a position to make a whole ton of money here versus other programs that aren't really going to be able to compete, that aren't going to have those opportunities. Do you see that being a problem or not so much?
Well, it depends on what you mean by problem.
Hmm.
So, first of all, let me restrict this particular part of the analysis, let's just say to a sport like men's football or men's basketball, where there's a lot of competition for big dollars
Right.
in TV money and whatnot. We already have substantial inequality in the NCAA in the sense that we have the Power Five conferences
Hmm.
who get the lion's share of the best recruits, and then everybody else.
Right.
Um, to the extent that the antitrust decision in Alston, and to another extent, the ability of players to exploit name, image, and likeness now are outside the regulation of the NCAA. The direct consequence of that is the opportunity for different schools and different conferences to compete against each other in terms of the opportunities they provide to student athletes. For example, schools might, under the Alston decision, begin offering much larger amounts of financial aid to the point that the financial aid package becomes a little profitable.
Hmm.
They could compete that way. And name, image, and likeness, absolutely. Depending on the kind of person you are, maybe you really would like to go to USC or UCLA because that could be your way into an acting career, even if you're in a minor sport or if you're in a major sport, but maybe not, a real legitimate NBA or NFL prospect.
Right.
Will that be a competitive advantage versus Brigham Young University?
Hmm.
Yeah, it might be.
Okay. Another issue that I, was sort of thinking about when you look at this is you have, first you have this issue in, the NFL and other, sports where, I know, sort of you think about like the Cowboys, some years ago when, Jerry Jones decided that he wanted to be able to have his own sponsorships, his own advertising at the stadium, separate and apart from, what the NFL was doing at the time. The NFL, sort of pushed back on that because you have this issue of, the league, and then obviously I guess not the teams, the schools in this case, have their own sponsorships, have their own branding, have their own opportunities that they seek. It's easy to see a scenario where that conflicts with some of the sponsorships that the athletes seek. So let's say if I'm a school and I have a sponsorship with Nike, but I'm the starting quarterback, but I've got a sponsorship with Adidas. um, you can see issues where some of these things can conflict. So do you think there'll be like a governance problem, conflicts, difficulties managing this, or because it seems like it's just kind of open season the way that it exists right now? Do you see any conflicts among brands and sponsors kind of being upset with each other or conflicting with each other?
There's the potential for some conflict. I'm guessing that we won't see a ton of it right away, but it may
Hmm.
come out. Most of the state statutes that permit athletes to exploit name, image, and likeness say in the statute that the schools retain some degree of power
Hmm.
to prohibit the athlete from engaging in name, image, and likeness exploitation that conflicts with team contracts.
Okay.
Now, of course, what does conflict mean?
Hmm.
Uh, does it mean, well, the school's a Nike school and therefore you can't do Adidas? Or
Hmm.
does it mean only that the school's a Nike school and you can't do Nike,
Hmm.
right? Uh, if you have Dunkin' Donuts as a team sponsor, can the athlete do Starbucks?
Hmm.
Can the athletes do Krispy Kreme?
Right.
Uh, The other, let me just, what I think is a really interesting policy question here is also when we talk about conflict, conflict for what reason? Is it conflict for reasons legitimately related to the conduct of sport? Or do these laws, or is our system set up so that the university really retains a lot of economic control over the athlete? So, for example, let's just take shoes.
Mhm.
A university might enter into a contract with a shoe company or a clothing company that says we'll outfit the entire team in Nike shoes.
Mhm.
An athlete might say, "Well, I want to wear Adidas shoes."
Right.
That could be for profit or just because those are my lucky shoes. That's what I wear.
Right.
Why does the school have the ability to force the athlete to wear the shoes? Now, I understand if you're on a team, you wear this team, you wear the team issued jersey and stuff,
Mhm.
but I'm not sure why that extends to something like shoes or sweatbands or things like that that aren't related to the conduct of the game. Of course, dark jerseys, light jerseys, we get that. But does it matter what shoes somebody wears? And why can the school effectively sign the athlete's rights away to choose what shoes she puts on her feet?
Right. Now, it's sort of, going back to the economic issue in tandem with, sort of what's happened here with college athletes not being able to make money. You've had this other issue within the world of sports and within the sort of the legal world, political world of, sports betting becoming more and more legal in more and more states. It's as simple as being able to go on your phone and play some bets on some games. For the longest time, in most of the country, that was not something you were able to do. But now it seems like one by one, in recent times, more and more states are Massachusetts has sort of resisted this, but now I know there's sort of a bill that's come out that's being considered with respect to this, and it seems like that's kind of the direction that things are going in. And a lot of folks are concerned that when you have gambling, and obviously gambling something that has some problems that can come along with it. If you've now got a situation where these student athletes are able to make money, you've got people uh, you know betting on games. I mean, it's not hard to see a scenario where you can have situations where, let's say, there's a call goes a certain way in a game, or an athlete does something, throws an interception he probably shouldn't. I mean, you can start to see how, when there's a lot of money that's being introduced into the picture, and then you start applying scrutiny to these things, that you could have controversy, you could have, I mean, I don't want to say corruption, but it does sort of open the door once you introduce money into the picture, and you introduce, gambling and sports betting into the picture, of things going awry. Or do you think that concern that some folks have is overblown, or is it too early too early to tell, or what do you think about that?
Well, the existence of gaming with respect to sports always raises the possibility of corruption. For example, match fixing in tennis. There was a
Hmm.
big scandal about that not too long ago. However, it isn't apparent to me that allowing athletes to profit from name, image, and likeness changes that equation. In fact, you could argue that it lowers the possibility because, if you were a bookie trying to fix a game, you've got a relatively easy mark if you can find a player who's suffering economically
Hmm.
and you're offering the player, a few $1,000 to miss a few free throws. Yeah, you could do that, right?
Hmm.
But if the player says, look, I can go to the local Starbucks and get a sponsorship deal there,
Hmm.
maybe that person isn't as susceptible to corruption. I think you can make that argument as well.
Interesting. Okay. So I guess going forward, sort of looking at the landscape, ahead here for college athletes. I mean, this is sort of uncharted territory in a number of respects. What do you see as, particular, just sort of, I don't know if you'd say challenges, or things to watch going forward? Because now we've got, this season that's coming up upon us here, and obviously everything that, everything that sort of lies ahead. I mean, what kinds of things should folks pay attention to as we kind of move forward in this kind of new and sort of novel environment where student athletes are now able to make some money?
Oh boy, I can think of a bunch here.
Hmm.
One of them is how is this term conflict interpreted by universities?
Hmm.
It's not just an antiseptic legal question, it's one greatly bound up with how do universities perceive their self interest.
Hmm.
So, for example, one might think that universities be very, um, will interpret a lot of agreements to be conflicts with their agreements because they want to hoard all those economic opportunities to themselves.
Hmm.
That could happen. But there's a flip side. Every time an athlete gains public exposure in an advertisement, a public appearance, or whatever, that athlete becomes a walking advertisement for the university, which is one of the reasons universities like participation in sports in the first place. It's free advertising on TV. So it's also possible that universities will be relatively lenient to athletes to allow them to pursue a number of potentially conflicting opportunities because it's free publicity for the university. So I think that's one thing to watch. I think a second thing to watch is the problem of enforcement or following the rules.
Mhm.
There are two borders that I see as being really tricky. One of them is pay to play or pay for success, and the other is in recruiting.
Mhm.
So, for example, let's suppose that you were a hotshot young golfer. Maybe your name was the new Tiger Woods, and you've already won 3 U.S. amateurs by the time, or U.S. junior amateurs by the time you come to college. And yeah, people are interested in you,
Mhm.
and they sign you to sponsorship arrangements. Uh, just what do those sponsorship arrangements say? Are there escalator clauses if you start winning tournaments and things like that? So there's lots of ways in which you can imagine this seemingly innocent sponsorship arrangements raising questions about pay for performance. The other is recruitment. This is not supposed to be a recruiting inducement.
Mhm.
It's supposed to be something the athlete does on her own upon being enrolled in college. But for goodness sake, how can it not get into the equation? If an athlete asks a coach, say, coach, what kinds of opportunities for sponsorships would I have if I come to your university?
Mhm.
What is the coach supposed to say?
Right.
And how many coaches would say, I'm going to be totally above board and say, I can't say anything to you about that?
Mhm.
And what happens if casual conversations, and I use the word casual perhaps advisedly, are had between athletes and potential sponsors before enrolling in a school?
Mhm.
How do we view those things? So I think that that's also uh, very interesting. And then the third thing that I think would be very interesting is to what extent are athletes, young people, going to be successful at avoiding the kind of exploitation that many young people find when they become celebrities, right? The world is full of hot young rock stars who signed initial contracts that were really very exploitative of them.
Mhm.
The world is full of athletes who have, gotten into bad arrangements with agents or managers. Will college athletes have these problems? I think that's going to be something that's something to watch as well.
Okay. Now, to your point about sort of pay for performance, do you think that that enhances competition among athletes, makes the sports better because students now they have a financial interest in performing really well, or do you think it goes the other way to where it becomes exploitative, where it becomes something that's detrimental to the sports and to the athletes, or maybe something else?
My general view is that someone who is a good enough athlete to be a Division I college athlete is an incredibly competitive person anyway.
Right.
They don't need motivation to try to win games. They hate to lose. So I don't
Hmm.
think that's going to change that much in terms of how the games look. Whether incentives are good for people in performance, I mean, that's an age-old compensation question that professional sports teams have resolved. And yeah, in some cases, we do
Hmm.
provide bonuses for championships, all pro designation, whatever.
Okay. Now, the other point there about sort of schools, sort of the role of schools, and sort of offering, or sort of trying to enhance or market the opportunities sponsorship wise that might be available at their schools, compared to another school that someone might be considering. Do you think that, and I guess this goes towards the Supreme Court's decision, does the decision at all restrain or restrict or create an issue down the road where there might need to be some governance over this issue? There might need to be some kind of management to prevent the sort of issue that you're describing. Does this decision prevent the NCAA from having any oversight at all over this issue, or is there sort of sufficient latitude to where the types of issues you describe as you go down the road, if there needs to be some type of administration over this to sort of prevent the types of things you're talking about, is the NCAA and are the schools still able to do that, or is this just completely open season for the athletes?
It's not open season for the athletes. So this goes back to the point that I made earlier that the Alston case is narrowly addressed toward grants in aid
Hmm.
or academically related aid. And that's all that it's about. The court scrupulously goes to pains to say, we're not saying anything about the other stuff. And so that stuff, I think, remains an open question. At least on the face of the opinion, the NCAA could retain some role. Uh, they probably always will have some role that they could play in it. But how restrictive it is really an open question. So, for example, one could read Justice Kavanaugh's dissent, where he expresses great skepticism about the NCAA's role.
Mm-hmm.
How many justices share his views?
You say when you just for folks watching, when you say dissent in terms of
Oh, I'm sorry, his
yeah,
concurrence.
concurrence. Okay,
I
yeah,
misspoke.
because he
Justice
concurred with his.
Kavanaugh's
Yeah.
concurrence, yes.
Okay. Okay. So another question I want to ask is, so when you kind of look, again to the road ahead, with this issue and the way that student athletes are going to be able to make money, how, and I guess it's something that's going to have to be determined, but you've got obviously a pretty narrow window to make money as a college. I mean, these careers are not very long. How do you see this start? Is this something that you think will begin in high school? Does it begin when you get to college? Does it, like, I mean, this is obviously very new for the industry and for student athletes in particular. Like, what are some, I guess, because I know, like when there's movies like Draft Day and sort of these different, the movie with Tom Cruise where he's an agent, where there's a sort of romanticized, you get drafted by the NFL, you get all these people, but for the student athlete going to college, how do you see this process working? Is this something where, I signed to go to this school and now all these brands are coming after me? Do I have to go to college and perform really well in order to develop a following such that brands want to come deal with me? Or how, like, if I'm a student athlete, how can I expect this new world to sort of work?
I think it's highly individualized.
Hmm.
There are surely female gymnasts who have massive Instagram followings at the age of 16.
Right.
The day they sign an NCAA letter of intent, if ever they do, they have the stream to monetize if they haven't monetized already. In fact, some of them may be Olympians and are already
Hmm.
signed to sponsorship deals. I think it actually remains to be seen exactly how that's going to affect. Well, it remains to be seen a lot of things. There are going to be others who will not have those opportunities because they don't become well-known athletes until they perform well in college.
Okay.
So I think it's highly individualized.
Okay. Do you see, just sort of wrapping up here, the obviously, an earlier point that I sort of alluded to, this idea that, there's obviously some sports, men's basketball, men's football, and really there's this sort of that inherent inequity between the men's sports and the female sports in terms of, viewership and following, and obviously brands and sponsors are interested in how big your audience is. Um, is a matter of inequality, is a matter of gender inequity, um, and I know this is sort of looking way down the road, perhaps not that far down the road. Um, I guess, what do you make of that issue now that the door's been open for athletes to make money? It seems that it's inherently going to have an effect with the men and men's athletes and basketball, football, things like that are able to make enormous amounts of money, whereas females don't have that same opportunity. Is that something that is going to require something, because we know that obviously given the times we're living in, schools are particularly institutions of higher education are particularly sensitive to these issues, as much of society is now. um eh, and I know schools can't will sponsors to put money where they don't want to put it, but it seems like that's an issue, and it seems like it's something that might require some type of, I don't know if it's management, I don't know if it's, I don't know exactly what it takes the form of, but it seems like the door's been open for this situation where one gender sports are going to be able to be very profitable, now for these young people, as compared to the other. I'm not sure what you do about that or what's to be done, but it doesn't seem like that's, I don't know, something's going to have to happen there.
Boy, that's this is a big and difficult issue with
Hmm.
a lot of perspectives. Uh, so I think that your basic observation is one that's worth making, which is
Hmm.
it's entirely possible that those who already have the largest commercial opportunities will have even more. Uh, that's not entirely a surprise in a gendered world, a
Hmm.
sexist that has a lot of sexist problems. Uh, there will be exceptions. I
Hmm.
think there will be female NCAA athletes who are very successful at marketing themselves.
Hmm.
Again, maybe it's the gymnast or the tennis player or something like this that's really good at using social media that will actually make a lot of money
Hmm.
doing this. That's possible. I don't know it, but it's possible. Um, in the end, To the extent that our society has problems with gender inequality, neither the Alston decision nor the decision to allow athletes to profit, or rather the legislation to allow athletes to profit from name, image, and likeness, is addressed toward remedying gender inequality. So yeah, if there's gender inequality in the society,
Mhm.
those problems are still going to be with us.
All right. So another question I did want to ask is something we were talking about, before we came on, with regard to the antitrust issue that sort of underlays all of this is, sort of looking at the market. You've got the NCAA as the overall, sort of governing body of college sports, but within the NCAA, you've got, a ton of conferences, a ton of schools that all compete with each other. And as we understand it here, this Supreme Court decision in NCAA versus Alston is very narrow. I know that, like for instance, when I found out about the case because an ESPN alert popped up on my phone and it said something along the lines of, Supreme Court says college athletes can make money. It's something that I think is very easy for the public to interpret as, being broader than the decision might necessarily be. So could you talk a little bit about that, just within the NCAA, the real nuts and bolts of this, how it sort of differs from what a lot of people might think?
Sure. So it's very important to understand that the Alston decision is narrow in two ways. First, it's narrow in that it is about academic related benefits.
Hmm.
Right? So the NCAA still retains the power to say people can't be paid a salary,
Hmm.
but the NCAA has lost a lot of its power to regulate how much somebody gets as a grant in aid. The second thing to understand is that the Supreme Court goes out of its way to emphasize that individual conferences can have their own rules about what they will allow players to get in grants and aid. So, for example, the Ivy League has a no scholarship rule. If the Ivy League wants to continue having that, they can have that. If the SEC wants to have a much bigger, more generous financial aid program, they can have that. And the reason that the court is willing to allow individual conferences to have that leeway is that no individual conference has a monopoly over college sports. The reason the NCAA gets in trouble is because they govern all of it.
Hmm.
But the Ivy League only governs, it's 8 teams, right?
Hmm.
However many are in the SEC, that's all that are governed there.
Hmm.
And the court is much more willing to allow those conferences to do what they want because they have to compete against each other.
Hmm.
And that's exactly the point of antitrust law, to engender competition.
Okay. Now, do you think that that could create any, I guess not confusion, but issues going ahead where you've got, certain perhaps more lucrative financial or economic opportunities within one conference, if I'm considering one school that's in this conference, versus another? Or do you think that that's something where the market forces sort of figure it out on its own? Or, I mean, it seems like that's an important distinction that not a lot of folks really understand.
Absolutely. There
Oh.
could be very different implications in terms of what a grant and aid, scholarship aid
Mm-hmm.
means at a different school, right? It could well be that at some conference, uh, if you get a scholarship to the school, it's rather limited. It could be that in another school, it's quite large in another conference. And of course, the commercial opportunities that one might have, right, when we start talking about the ability of the athlete to exploit name, image, and likeness, could be very different in one place versus another.
Okay. And so I guess my last question would be, just looking at that last, I guess, observation, you can correct me if I'm wrong, is it seems like at the end of the day, antitrust law, the purpose of antitrust law and the role of courts is to sort of maintain, that balance, that, sort of equilibrium where things are sufficiently competitive. And it seems like just going off of that last point where, if I'm a student athlete and I'm considering different schools, now that is something that I'm have the ability to consider, okay, well, if this conference has, more lucrative opportunities than this other one, well, that sort of engenders some competition between the conferences where if I'm the conference and I'm losing top recruits because they want to, be able to make some money over here. Maybe now I have to change my policies to sort of reflect the market better. Is that, sort of part of the court's rationale to sort of preserve that balance, or is it just an unintended consequence that you've got so many different conferences with so many different rules that it sort of sets this up?
I do think that that's what the court and by extension antitrust law has in mind.
Mm-hmm.
People should have choices. You have choices about the car that you might buy, right? How
Mm-hmm.
much do you want to pay for it? What features does it come with? If you're a student and thinking about where you want to go to college and you're going to go to play sports, you should have some choice. It shouldn't be just a uniform package that you get everywhere.
Mm-hmm.
I think we should also pause for a moment to reflect on exactly how this is going to affect people. It's easy for us to imagine in our minds the highly coveted prospect, that everybody wants,
Mm-hmm.
DeAndre Ayton or, LeBron James, had he chosen to go to college.
Mm-hmm.
Of course, those people might become the subject of very, very competitive bidding. They already are, right? People come to campus, they see the swanky basketball dorm that I think it's Kansas has, they all have swanky facilities. So there's already this kind of competition that's going on for the top recruits. It's just that another element has been added. There might be a little bit more money in the academic aid, depending on where you go. There might be different name, image, and likeness exploitation opportunities. But we have to remember that the vast majority of people who play Division I sports are not that heavily recruited. They
Mm-hmm.
may only get one scholarship offer or just a couple. And even if they are given those offers, it's not as if they're so high on the coach's recruit list that the school is going to start extending itself
Mm-hmm.
for that person.
The last question I wanted to ask on that is obviously something that's existed with respect to college athletes and money. Is there have been incidences, and I'm sure there's many that we don't know about and might never know about, of money under the table, schools, coaches, putting cash in a brown paper bag and trying to influence things one way or another. I mean, there's all kinds of stories that are out there, and some stories we might never know, but it all sort of goes under the broader umbrella of corruption and things not working the way that we ought to tend to think that they should. Do you think that this new source of revenue for college athletes reduces the role of that in sports, or could it maybe increase or have no effect on it?
You're talking about the addition of revenue from name, image, and
Right,
likeness
right.
exploitation.
In other words, now that I'm not so now that I have other ways to make money as a college athlete, that might not be so enticing anymore, or maybe it still is.
I think it's both.
Mm-hmm.
There will be some people who are certain that they will have commercial opportunities and will say, I will choose based on commercial opportunities I know I can raise when I become the star quarterback at Alabama. I don't
Mm-hmm.
have to worry about improper inducements to get me to go to any particular school.
Right.
There will be others for whom endorsement deals may be proposed quietly and lucratively that will fall prey to that. And I
Mm-hmm.
think that the NCAA will have a terribly difficult time enforcing this border between what's legitimately found by the athlete and exploited and what is put there improperly as inducement to attend a particular university. It's already extremely difficult for the NCAA to police improper recruiting behavior now.
Mm-hmm.
There's so many stories that one can hear that, in many cases by precipient witnesses,
Mm-hmm.
that don't get sanctioned, that this is just another and perhaps potentially very large problem that the NCAA is going to have to fight.
Mm. All right, Professor Yen, that's all I had. Well, again, I'm Tom Blakely. There's been Professor Yen on the Just Law podcast discussing the NCAA versus Alston case. It's going to have, I guess, implications for us to pay attention to in the years and the seasons that are ahead. So, Professor Yen, thanks again for coming on.
Pleasure.
All right.